So hello everyone and welcome to today's webinar, Staying Compliant, the latest health and safety legal update. I'm Callum Greaves and I'm the head of marketing here at Notify Technology. For those of you who aren't aware of Notify or who we are and what we're about, we're a health and safety software partner who are on a mission to ensure everyone works safe and goes home safe. We also like to put on events and webinars to help you stay informed about changes in the industry and to give you some practical insights that help you in your role. I'm also excited to share that today I'm joined by today's speaker, Emma Bowens. So Emma is a partner at Gunnar Cook and a specialist in safety law. She has over 20 years experience in law and is a 2-time winner of the Regulatory Team of the Year at the Northern Law Awards. She acts for a broad range of clients of all different sizes and in different sectors, following allegations made by the police, the HSE, local authority, the Environment Agency, CQC, and also trading standards. She also runs her own training company, so Bowen Solutions Limited, and provides popular interactive training and immersive mock trials, again, to help you guys stay compliant. So welcome, Emma.
Thank you. Good to be here. Thank you.
Well, so in today's session, we'll reflect on 2025 and unpack the outcomes and practical implications of several significant cases that occurred. We'll then explore what they reveal about the current regulatory priorities and the HSE's approach to compliance and enforcement. We'll then look forward to the year ahead, highlighting the trends and developments likely to influence how health and safety is managed in 2026, and what you can do now to strengthen your position to reduce risk and demonstrate compliance. So it's a busy session. We've got lots of attendees on the call, which is brilliant to see. What we'll aim to do is leave 15 minutes at the end of the session for any Q&A. So what I suggest for now, what we do, and obviously throughout the session, is feel free to pose your questions in the Q&A box that you'll see there. And obviously we'll get to them at the end. So yeah, around 2:45. But without further ado, I'll hand that over to Emma.
Thank you so much. Thanks, Callum. So as Callum said, he's already done the introduction, but as he said, I'm a regulatory lawyer, which means that I spend my days investigating very serious health and safety incidents, so fatalities and life-changing injuries, in addition to sort of helping clients through PACE interviews at the police station or with the HSE or other regulators, and then also representing clients at court and at inquests as well. And as Callum has said, he's given you a lot of information about me, but I also have my own training company as well, delivering training like this, and also training such as mock trials and what to do if an inspector calls, the sort of crisis replay type of sessions, plus many more as well. So it is going to be a very busy session today. We've got a lot to get through, and honestly, I could probably talk to you about this sort of update and these cases for many hours, probably till about 5 or 6 o'clock, but you probably wouldn't appreciate that if I did that. So we'll spend the next hour going through recent cases, HSE statistics, their trends in terms of what I've seen in my practice, and look ahead at 2026 and take some practical steps in terms of what you can do to help you remain compliant. So the first case that I want to look at is just in relation to the cases. I haven't mentioned the names of the companies, the defendants in the slides, but I am happy for the slides to be shared. So I will tell you the name of the company, but it's just easier when we're sharing slides not to mention the company name in writing. But I have also broken the golden rule of 3 lines, 3 bullet points and 3 words each line or whatever it is. But I've done that purposely because I just wanted you to get as much value as possible from this session so that you've got a lot of information about each case. I might not get the chance to go through every single aspect of that information, but I'm always here if you have questions about the cases or if you want to have a discussion about it. So it's completely fine. So this case here, this is in relation to Biffa Waste Management. It's a waste management company, and the case concerns pedestrian vehicle segregation. And I'm going to show you a video in a few minutes. It will show you what the site looks like, and you will see the extent of the pedestrian vehicle segregation. They have, demarcation and lots of, sort of making sure that people can't sort of stray into the wrong areas. And it is really quite an impressive site. However, in August 2023, there was unfortunately an incident where a 57-year-old man was killed at the site by a reversing wagon. And as a result of the incident, when the investigation was being considered, the regulators looked at the CCTV provision, and this was sort of in the sort of days and weeks leading up to the incident, and they could see that the pedestrian routes and the barriers that they had been installed, but they just weren't being used. So people were not following them, and it seemed that no one was really asking people to follow them, and they were just being ignored basically. And one of the comments from the HSE inspector, I've included that on the slide, that it was a casual attitude towards health and safety, with workers treating a high hazard site like a playground. And do watch out on this video for the section where you see some people playing football on the site. So let's take a look at this now. So let me just rewind this. So you can see the barriers there in yellow. Getting very close there. This is the example here. Playing football. Almost more difficult, I think, to go use the routes that these guys have taken. So the organisation, obviously, very large organisation, they're fined 2.5 million in relation to this case. And you'll see in the corner of my screen there the photograph, which is a really sad image, actually, and something that the HSE are doing much more these days is producing the photograph, which is just seconds before the incident, and it shows just how if the site had been following the rules, if the management had been making sure that people were supervised and the rules were enforced, then he would have been in a different position at the time of the accident. So the judge had said that there was a breakdown of supervision and safety culture, that managers failed to intervene and enforce the pedestrian vehicle segregation, which you can see on the CCTV footage, and that unsafe practices were allowed to become the norm here. And obviously there was a failure to monitor and review the safety arrangements. And I wonder whether what we would see on your CCTV, if you do have CCTV footage on your own sites. And I'm asking this question, I suppose it's a rhetorical question really because of the setting we're in, but if we were face to face, I'd be asking you if you do carry out spot checks of your CCTV. And what you might find if you did do that, it might be a useful exercise just to test, to make sure that supervision is as effective as it should be. I do also wonder whether when I see footage like this, there was a similar case called Alutrade from a couple of years ago, where there was similar footage put together, which showed lots of examples of management not intervening when there was unsafe practices. But I do wonder whether the people that are in this footage even have any concept of the fact that when they're not following the rules, that it could be in some time to come, they are part of a video being shown in a courtroom, in an inquest, shown to the family members of someone who's died in relation to the sort of non-compliance on site. So yes, a very sad case, but absolutely a really strong lesson for people to think about the importance of supervision on site, and maybe showing this to some of the supervisors and site managers to show them just the implications of not quite getting that right. So here This case is in relation to individual prosecution and also the time it takes for prosecutions to come through. So this is an NHS Trust case. So it's NHS Trust, North East London Foundation Trust, and they were charged with corporate manslaughter and a breach of Section 3 of the Health and Safety at Work Act in the alternative, which means that the prosecutors, if they don't succeed in successfully prosecuting for corporate manslaughter, then they would fall back on the lesser offence of Section 3, which is slightly easier for a prosecutor to provide all of the elements in those cases. And obviously fines are very significantly higher for Health and Safety at Work Act offences than they used to be before the sentencing guideline came through. So often you do find that prosecutors will prosecute under the Health and Safety at Work Act for that reason. But in this case, it was a corporate manslaughter case against the trust, but interestingly also against the ward manager. The ward manager was prosecuted in their individual capacity. So there's a gross negligence charge, negligence manslaughter charge for that person, and also a breach of Section 7 in the alternative. So this related to an incident back in July 2015, a very, very long time ago, as a 22-year-old person who was receiving treatment in under the Mental Health Act in hospital, and sadly she took her own life using bin bags from a shared toilet. So those bin bags had been removed from her own bathroom, but not from the communal bathroom within the premises. Now, she had made several previous similar attempts, and between this quite short time period, 15th of February to the 9th of June, there were 18 incidents, and the judge had said in his sentencing remarks that at least half of the bags were sourced from the communal toilet. So clearly a repeated issue, a repetitive issue there that needed to be managed. The trial in this case lasted for 7.5 months, a very long period of time, ended in June last year, and so the case was just coming for sentencing now in November at the end of last year. So the NHS Trust was fined £565,000 in relation to the Health and Safety at Work Act offence, and the judge had said in his sentencing remarks that they had ignored concerns raised by employees, by workers, and also by this person's mum, who raised some real concerns about what was happening in the premises, and they also failed to make the appropriate changes following the incidents. There was breaches over a long period of time, and also what is quite interesting is the way the judge talked about the poor recording of incidents. So this is one of those cases where the sentencing remarks are available online. You can watch the judge provide the sentencing remarks, or you can get them in writing. But if you're ever in a situation where you want to talk to people about how important it is to record incidents in sufficient detail so that you can identify whether there might be some trends or some issues building within the organisation, is a good case to have a look at, because he's very, very critical of the level of detail included in those reports, and in fact many cases and issues weren't reported at all. So the ward manager received a 6-month custodial sentence, but that was suspended, and that person had to do 300 hours unpaid work. From the sentencing remarks, it looks like part of the reason why the sentence was suspended was because of the fact that they'd had to wait for 10 years for this case to come to court. So for 10 years, this was hanging over them, and the impact that must have had on them, not knowing whether they were going to go to prison or not. So it's very difficult. Another aspect that the judge had picked up on, though, was in relation to the person's accountability. So he said, whilst you regret Alice's death, you have no real insight into what you did wrong, and I find the fact that you clearly remain in a state of denial very troubling, which no doubt impacted on the sentence given in that case. So again, just an interesting case to look at in terms of how that person comes across. I have another case that's quite similar, has similar comments, but just how important it is to be showing remorse and the fact that you accept responsibility for what has happened. I wanted to show you a case about contractor management because this is something that comes up quite frequently. So this is a case that came to court in May 2025. It was from an incident in August 2022, and it was an education trust, so it's Bishop Buick Catholic Education Trust, and a gardening contractor called Green Yem. And they had been instructed to cut down a tree, and a 68-year-old member of the public was walking near the tree and part of the tree fell, and she was knocked into the road. Now, thankfully, I mean, she was injured, but it could have been a lot worse if there'd been vehicles. I think she was into the path of a vehicle, but they managed to stop. So it was found in the investigation that the contractor was not an arborist, not qualified to do this work, wasn't qualified to use a chainsaw, but the organisation hadn't completed the checks in relation to how this work would be done. So there wasn't the discussion about what the plan was in relation to the works and the qualifications that the person had. The other difficulty here was the fact that the works continued after the accident happened. So instead of stopping works and really taking a breath, thinking about what caused this incident, again, are we making sure if we do progress with the works, are we making sure that this isn't going to happen again? They carried on, and obviously the HSE, that was a big issue for them. I had a case many years ago now, but in the manufacturing sector where there was a serious incident, and the person who was in charge of the site at the time felt that they were very clear about why the incident had happened, what caused the incident, but they didn't investigate, and he started the machine up after the police had left. And he was prosecuted in his own personal capacity for doing that, even though there was no incident, there was no issue, and there was nothing to change in relation to the machine. So he was actually right about his assessment as to what caused the incident, but he was prosecuted in his own personal capacity. And obviously the offence could result in a custodial sentence. So it's extremely worrying for him, as you can imagine. So these things do happen. So the lesson here is making sure that we have that process, even if we feel we know what has happened and why it's happened, making sure we're going through a process to investigate, and you can demonstrate that to a regulator. So this organisation was fined £20,000 plus £4,000 worth of costs, and the contractor a 12-week prison sentence, but that was suspended for 12 months, and he had to do 200 hours unpaid work as well. I wanted to include a risk of harm case because, bearing in mind, I'm sure you know that in health and safety cases, there doesn't have to be a significant injury or a significant incident that happens that could result in the prosecution. If there is a breach, that is sufficient for regulators to prosecute. So this is a case that came to court in March 2025. And it relates to a period between 2017 and 2020. And there was a carbon monoxide leak at a primary school around the sort of February 2020 mark. And there was a lack of boiler maintenance. And if the boiler had been maintained or serviced, then it would have been taken out of service straight away. It would have been deemed dangerous. So they could have quite easily identified the issue. And this is obviously a gas safety breach. So some of the staff and the pupils were ill to the extent that they were having experiencing nausea and headaches, but there was no sort of big incident or sort of serious harm, that lasting harm for those individuals. But regulators still prosecuted this case and the company was fined as well, £13,000. So that is Eastern Bartonshire Council case there. So this is just one that I could have chosen from so many. There's so many fire cases, for example, whereby the fire authority recognised there's maybe problems with fire risk assessments or compartmentation, etc. And those cases can often be prosecuted because of the very risk of getting it wrong. Often it happens when you don't move quickly enough to rectify the issues, but and certainly it will happen then. They're almost backed into a corner. They can't really do much else if you won't fix the problem. But yes, I have seen that situation. So if people are saying to you, well, that there hasn't been an accident, so we're fine, we're not going to be prosecuted, it doesn't always hold true. This is a case in relation to occasional work from April 25. The incident happened in 2022, and this is Bury Metropolitan Borough Council, and this was in relation to installing a Christmas tree. So the operations manager was up in the scissor lift trying to straighten the tree out, and it overturned whilst he was in the basket, and he suffered some injuries in relation to that incident. But there was no risk assessment, no training on how to use this as a lift. It's just an occasional task, and that went ahead without all of the health and safety procedures in place. So again, often people will say it'll be fine. That's what, if I had a pound for every time someone said that to me, it'll be fine. We'll just, that's what I thought. This seems to be that type of case where we just sort of carry on with the work, thinking it won't take long and it will be done very quickly and it'll be fine. And it may have been fine many times before. I don't know in this case, but organisation was fined £200,000 for this breach. I also wanted to include a company in liquidation. There's many to choose from each year. I could always pick from many cases, and this is a common question that I get asked when an incident happens. Often organisations that are struggling, the directors will say to me, the organisation is in financial difficulties. We have been thinking that we may not be able to continue forever. We don't know what's going to happen. What happens to a potential prosecution if we do, if the business is in liquidation or if it's wound up? Now, obviously, if it's in liquidation, it doesn't necessarily mean that you are not going to be prosecuted. In fact, in my experience, what they often do, the prosecutors will add in individual directors, making sure that, because the likelihood is, well, it may be that the fine is never going to be paid, but making sure that directors are accountable for what has happened. So this case was from 2018, a long time ago, where they were removing some redundant steel cleaning machinery from a site. A 42-year-old worker fell 20 foot and unfortunately died at the scene. There's no risk assessment, lots of problems here, no organisation, no plan. Supervision was not in existence, and the work wasn't being carried out safely, and there wasn't sufficient training either. So the organisation was still fined £90,000, would just be one of the creditors of the organisation, and the director pleaded guilty to a Section 7 offence and was fined £8,500 and was ordered to pay costs of £8,500 as well. And the court saying that, or the HSC, sorry, making the point that it demonstrates that, placing the company into liquidation is no bar to a prosecution, which is important to be aware of. Apologies, that case is Surface Technic Old Hill Limited. Failure to comply. I'm hoping you can see these pictures quite clearly. If not, do go to the HSC's website because they are quite interesting to see. So this is a property developer in London. It's NoFax Enterprises Limited. And for a 13-month period between 2020 and part of 2021, there were 4 visits on site across this period. And the HSC had identified problems, and you can probably see them yourself from the photographs. Quite astonishing, really. And there's risks of falling from height, risks in relation to fire safety as well, construction dust. So the enforcement notices have been issued, 9 of them in total, and not complied with. And this is linked to the point that I made earlier, that I think in this kind of situation, you're almost leaving the regulator with no other option but to take action, because if they don't and something happens on site, then obviously they will be looked at as to why they didn't see this through once they're sort of hitting a blank, a sort of wall in terms of trying to achieve compliance. So I'm sure nobody here would be in this situation where you wouldn't be complying with enforcement notices, but just in case, that assists in terms of showing what can happen if you do. Foreseeable risks. This is a large organisation that was fined here. So this is British Airways. They were fined £3 million in this case. So this is from two separate incidents that happened, one in August 22 and another in March 23. And the first in relation to baggage containers from being removed from an aircraft, and this person slipped from the travelator and fell 1.5 meters. Now, the HSE had spotted these gaps during a previous visit and identified this with the organisation. The organisation was making changes and they'd started to retrofit these sort of extendable guardrails, but hadn't got to this particular site. And then the second incident was in relation to a 3-meter fall from an elevator. And in both cases, it was recognised just the significant impact on the individuals that were injured and both needing a very, very long time off work. So they were fined £3 million. I wanted to talk about this case, the paddleboard company. This is a case from April 2025. I've given you a lot of information here in relation to the incident, but I'm not going to go through all of the details. You may have seen this in the press. It's been quite well covered, and the sentencing remarks are available online, both in written form and also for you to watch the judge deliver those sentencing remarks. And it's quite an interesting case and well worth looking into it in more detail. But essentially, in 2021, we have a stand-up paddleboard company that is offering a paddle that is easy, suitable for beginners. They say they've got fully qualified instructors, and unfortunately 4 people died, and the owner is charged with 4 counts of gross negligence manslaughter plus 1 charge in relation to Section 3, a breach of Section 3 in relation to the survivors. She pleaded guilty and was sentenced in April of last year. And it's quite incredible, the list of things that went right. And I think that in this kind of case, it seems like the approach is just that they think the situation's going to be okay, and just haven't looked into all of the necessary requirements to keep people safe. So didn't ask people about their experience, didn't get next of kin details, which resulted in a 12-hour delay of some of the families being told of what's happened, which is dreadful. Didn't observe the weir, the flow of the water, the weather warnings in relation to that particular day. And the judge said that Neris Lloyd is the person that was prosecuted, and the Salty Dog is the company. But her approach to health and safety was abysmal, and that was against the background that she was trained in risk management. So she was a police officer herself, and she was on sick leave, and she was also an RNLI volunteer, and so had completed risk documentation regularly. So she'd painted this false narrative straight after the incident and disproportionately blamed her colleague who had died in the incident. And the judge really said that she had a real focus on herself straight after the incident. And there's a quote there as to what was said about not showing remorse, because on her social media account, for the years that it took to bring the case to court, she presented as though her life was carrying on as normal, completing triathlons and things like that for charity, but nonetheless causing some upset to the people who died, to their families. So she received an immediate custodial sentence of 10 years and 6 months in relation to that case, and is serving that sentence now. And just very quickly before we move on to other aspects of the talk, this is the Cambridgeshire Council case, and it really is about responding to previous incidents. There was a number of previous incidents on the guided busway in the area where 3 people had been killed over a long period of time between 2015 and 2021, and this is people trying to cross the road or people being struck by the vehicles as they were passing them. The organisation's fined £6 million, which is a lot of money for local authority cases, because the court obviously take into account the financial circumstances of the organisation and the amount of money that they have available to pay a fine. So £6 million for this type of organisation is a very significant fine. But the judge talked about them having a blinkered and rigid response to the fatalities that had happened. So they didn't review their risk, or didn't produce a risk assessment until 2016, which is long time after the first fatality, which obviously was heavily criticised, and they defended or appealed the enforcement notices that were served in 2018. So they did take some action, but it was obviously they were still guilty. They did take some action afterwards, though, to remedy the issues. And interestingly, the court identified that where they looked through the accounts in the council's accounts and showed that they'd had put £18 million in reserve for legal risks, which they had assumed may account for this case, and they were anticipating a high fine. They were given 3 years left to pay. That is a quick run through of the cases. Again, you see why I could talk about these things for so long. They had so many other cases as well that I could have talked to you about, but I wanted to go through and look at the HSE statistics. Obviously, fatalities, 124 fatalities. You probably know this already, and I don't want to go through all of this in a huge amount of detail, but that number's come down 14 from last year, which is good. But we don't seem to be making huge strides in terms of reducing the numbers, albeit 14 is fantastic in terms of reduction. But for the last sort of few years, the numbers have remained roughly the same, or just sort of up and down a little bit. But the really striking numbers is the 1.9 million people suffering from work-related illnesses. And I've put the stats on the screen there. So 964,000 people suffering from work-related stress, depression, or anxiety, and then over 500,000 people with MSD as well. As you can imagine, this is a big issue for the HSE this year, and we're going to come on to that in a moment, but you can see why with those kind of numbers. You might not be able to read this very clearly, but if you are very interested in this sort of work-related ill health, stress elements, useful to have a look at the type of industries that are caught by this, or the ones that are sort of higher up in the list of having people with this self-reported work-related stress, with construction coming sort of halfway down the table and agriculture almost at the bottom, which to me is quite a significant issue, given that or interesting point to look at, because ordinarily when we're looking at fatalities, construction, agriculture are always sort of right at the top in terms of areas where fatalities happen. So it'd be interesting to think about. I think there'll be some studies in future to think about why that is happening. But I did want to just flag the labour force survey. You may already know this, but I just think in terms of the context of those numbers, it's quite useful to be aware of how those statistics are pulled together. So for the labour force survey, so when they're asking about work-related ill health, they survey 31,000 households, and they talk to people who are age 16 and over, and they answer questions based on sort of their perception in relation to the questions that they've been asked. So the question in relation to this, in terms of stress, have you suffered from any illness, disability, or other physical or mental problem caused by or made worse by work in the last 12 months? Which is quite an interesting question. There's many things I could say in relation to that, bearing in mind that, this is very subjective for that person to interpret what is meant by a mental problem. Could it be, some people might have brain fog and think that or feel that sort of qualifies to answer that question, yes, or maybe an inability to focus at work, maybe. And yeah, so it doesn't also talk about how long that illness is suffered for. So someone may have brain fog for a week, for example, and then answer this question yes, but there's no sort of narrowing down of that particular those particular points. I raise that because when organisations are trying to benchmark themselves against this statistic, it's helpful to understand how the question is asked in the background to achieve, in terms of those numbers and how those numbers arise. So often the questions that you're asking will be much more pointed, which I don't think is wrong, but just to be able to explain the difference between the two sets of figures. I thought you might be interested in seeing these statistics again. If you are interested in this aspect, useful to go to the specific documents that relate to stress and the statistics and how they are put together. But just looking at the sort of the breakup between males and females, but the age categories of people who are reporting work-related stress, depression or anxiety. So not the youngest category, not the older categories, but those in ages 25 to 34. I mean, we could all speculate as to why that is, but perhaps something to do with the fact that maybe people of that age have, young families and things of that nature, and maybe that's an area that we need to look at in terms of supporting people to be able to do their work without excessive stress in their minds. But I do appreciate you have a business to run as well, and that's always the sort of counter argument to this, isn't it? And just quickly to put up on the screen the slide in relation to the type of what people feel that is causing their stress, and you can see that workload is very, very significant there in comparison to the other specific issues. So again, worthwhile thinking about in your organization. So if you are interested in the stress aspect, definitely look at those further statistics in those separate documents that are provided by, and if you struggle to find them, just let me know and I can help you with that. So why is this happening? The commentators will say, and sometimes the HSE will say, that it's in relation to, it could be because of COVID. It could be as a result of leaner working practices since COVID, or in recent times from a financial perspective, that some organisations where their management is in sort of a survival mode, if you like, in terms of financial strain, and that there may be anxiety in relation to financial strain in the organisation, but also for individuals as well, that makes them feel that they perhaps have to work when they're not feeling well, if they don't have sick pay, for example. All of these kind of issues. Skill shortage may play a part in it as well. In some industries, construction comes straight to mind in terms of skills shortage, and maybe others sort of trying to pick up the slack, and that can cause some problems and stresses too. It could be something to do with the sort of more honest reporting, so people feeling less concerned about saying that they feel stressed, which is right, and that sort of perceived stigma around stress is definitely reduced. And also the potential for hybrid working to be contributing to this, so people working from home and not really engaging with others as regularly as they previously were. So need to think about those kind of aspects in your organisation to see whether any of those might be causing your stress statistics to be higher than others. I'm not sure if you're aware of this, but if you're not, in November last year, the Keep Britain Working Review was published, and it is a very interesting read. It talks about 1 in 5 working age people being out of work and not looking for work, and that number has significantly increased to 800,000 people since 2019, and the age category of 16 to 34-year-olds with mental health conditions that are unable to work has increased by 190,000 since 2019. So watch out for this working well partnership, which sounds like a great way to, or the intention is for this to support workers through health conditions in the hope that they can help people to remain in work so that they don't fall out of the working system, which can sometimes be difficult to get back into. But there'll be more sort of occupational health support, more of a collaborative approach, so different agencies talking to each other and hopefully helping people, as I say, to remain within work. There's going to be a look at the statutory sick pay and as I say, that sort of collaboration piece. So definitely worth looking at that. The other document to look at as well, if you haven't seen it already, is the British Standard for Suicide Prevention. I'm not going to go into too much detail with this, but it is definitely worth a read. It is available free online and it applies to all organisations. It talks about prevention, intervention and postvention. It has some very helpful sections in relation to having conversations with people about suicide risks. And for me, I know that people I've talked to get very, very concerned about making sure they're not making the situation worse, and so they sometimes don't know how to handle the situations. There's some suggestions there which would be very useful to look at. In terms of HSE trends, the I always say new legal services division. It's not new now. It's been out for been in existence for a few years now, but certainly a lot of the legal enforcement officers have come from CPS or have a CPS background, I feel that the cases are approached very much more like a CPS sort of approach, whereas historically we had HSE inspectors who would be recommending a decision and principal inspectors would make that decision. It's more detached now from a legal perspective. It's a legal officers that would that those decisions go to. There's been an increase in the speed of investigations. There's a real focus for the HSE in terms of KPIs. They need to, report the number of fatalities that are dealt with within 12 months from receiving the case back from the police, and the number of non-fatalities within 12 months. And you can see that 94% of their non-fatalities are dealt with within 12 months. And but you've seen from the cases that I've talked about earlier that if you fall outside of that 12-month period, it seems to take a very long time to get to court. But there is quite a number of cases that are dealt with within the 12 months. I've seen an increase in the number of improvement notices, and improvement notices that are served a very long time after the breach was identified, and also prosecutions as a result of improvement notices. Some people will get an improvement notice and think that's it, that's the end of the enforcement action, but it may not be. Also, types of prosecutions, as I alluded to before, there are fewer corporate manslaughter cases going through the courts, or more sort of focused on cases where it's quite a clear situation where there's a gross breach which has to be proved in corporate manslaughter cases. And so maybe more of a, given that the fines are very significant for Health and Safety Work Act offences, more of a sort of focus on those cases coming through. And then the conviction rate, 96% conviction rate, which is quite depressing. I talk to clients about that. Once you're prosecuted, 96% of organisations are convicted. And, I think that it reflects the nature of the Health and Safety at Work Act in terms of reasonable practicability. That you've got that reverse burden of proof, whereby if you are accused of an offence, the prosecution have to prove that there was a risk, and then it's over to you. You have to prove that you've done all that's reasonably practicable, which is challenging, can be challenging. But also, it may be that a lot of cases are very sort of straightforward cases, and that's what's sort of affecting the conviction rate. Moving on to 2026, I just want to run through, I've already sort of covered to an extent of some of the things that you should look out for in 2026, but I just want to sort of highlight a few of the thoughts that I had. So for one, for me, is bringing home the reality. So the cases that I've talked about today, absolutely talk to your organisation about these kind of cases and the people within it, showing them the videos of what happens, repeated failure to manage situations. I've listed there all of the cases that all of the issues that we've just talked about in those few cases. And if you have any points that you want to make and you need cases to go along with them, let me know and I can help you with that. But there are so many issues. I think when you talk to people about cases where they have actually been in court, it just helps people to realise that this can happen, because that is often the barrier, is that people think it's never going to happen to us, or it's never going to happen to me. And obviously these things do, unfortunately. HSE business plan, I've got the priorities focused on ill health. As you can understand from those 1.9 figure, the sort of very high numbers there. So naturally they are focusing on these aspects in terms of their targeted inspections, so asbestos, noise, MSDs and hazardous dust. And they have I think the expected enforcement rate there is, I think it's between 40 and 60%. So they're going to complete 14,000 targeted inspections in relation to those risk areas, and they expect out of that number to achieve about 40 to 60% enforcement action from that. So absolutely time to review your policies and procedures and processes if you're dealing with these types of risks, making sure that you're doing everything that you should, because you may well get a visit from the HSE. I've already covered this in terms of stress and mental health, but making sure that you stay up to date. You may not have been aware of the Keep Britain Working Review or the British Standard for Suicide Prevention. There's a lot happening at the moment in this field, and lots more information coming through. And so just making sure you're keeping on top of what is out there and the standards that, what is industry standard, because what is industry standard now in relation to stress in the workplace is absolutely different for what it was 10 years ago, or even less time than that. But so keeping up to date is very key. There will be a RIDDOR consultation in late March this year. That's the plan. And that could result in some changes to the definitions of occupational diseases and also dangerous occurrences. So we may see some changes to RIDDOR. I mean, RIDDOR is challenging at times. There are lots of grey areas in RIDDOR regulations, and lots of clients scratching their heads about whether they fall into one category or another, whether to report or not. It causes a lot of stress for organisations, and I think just some clarity in terms of this is what's reportable, this is not reportable would be helpful, albeit I appreciate that is a really difficult, it is a sort of very flexibly written for a reason, because there's so many different circumstances that we could be fitting into this. Hopefully there'll be some improvements to the process and improvements in efficiency as well, but we will see what happens there, but do watch out for that. So there may be a change by the end of this year. Lola consultation happened last year. This call for evidence happened last year. Same with pressure systems safety regulation. So look out for potential changes in relation to that in terms of guidance, legislation, and the ACOPs. There's a lot of talk about potential review of hybrid and remote working in terms of this longer term approach that we need to have. Obviously, during COVID, hybrid working or just working from home was something that was kind of introduced very, very quickly, and organisations needed to get up to speed with dealing with those risks in terms of DSE and the mental health considerations and lone working. But you do need to demonstrate how you're managing the risks outside of the workplace if you require someone, or someone is working in a hybrid or remote working situation. So look out for that as well. And the asbestos regulation improvements consultation period has just ended. So if you have asbestos in your building, what the proposal is that the analyst would be appointed by the client. So ordinarily you would get a licensed asbestos removal contractor coming in to do that work, and they would appoint the analyst that checks to make sure that once you've gone through the 4-stage clearance process, that it's safe to take that down, and other things. Of course, it's more complicated than that, but often they would be appointed by the LARC, but now in the future the proposal is that they will be appointed by the client, so you may have to do that yourself. And there may be a standard coming through for an accreditation for those completing asbestos surveys. The final one is really geared towards LARCs, but probably it's something that they would be more concerned with, but it's about some clarification about what is non-licensed work, which will definitely be welcome. Just a couple of more points. There may be an FFI review. I don't know. I may be just reading too much into this, but on page 23 of the annual report and accounts, because I read quite far all the way through these documents. There's some very interesting information at the back of these documents, which I haven't got time to tell you about, but yeah. Do have a look all the way through these documents. So they say at page 23, they are reviewing their application of the fee for intervention cost recovery scheme to ensure it's fair for everyone. We'll make sure that fees are proportionate and consistently applied when there is failure to manage risks that could seriously harm people. So proportionate, I don't know whether this means, I mean, the time it takes to investigate is the time it takes to investigate. I don't know whether they're thinking about a graded fee. I don't know. And maybe consistently applies means that there'll be more training for inspectors. I don't know, but let's watch this space to see if anything happens there. There is so many other things, and I'm conscious. I said I would go for 45 minutes, and I'm 50 minutes in, so I need to hand over for questions. But There were so many other things that I could have talked about, and this is just a few of them. But obviously, Martin's Law, we're expecting some guidance at some point in relation to that, and so you need to be prepared for that. ESOS enforcement notices are coming through. I've had one appeal already for these, where in terms of ESOS, there's an allegation that you haven't included the right companies or subsidiaries or parent company, etc. Some technical issues. Instead, you don't get a letter just saying, "Can you give us further information about this? We think you might be wrong." You get an enforcement notice, and I've successfully challenged some of those. So do think very carefully when they come through and check them and make sure that they are actually right about what they're suggesting, as opposed to just accepting it. I know, I'm sure you wouldn't, but do sort of look at those carefully. The future of jury trials is a whole other discussion, which could take us 45 minutes, well, and longer, but we'll see what comes through in relation to that. And of course, AI is always on my list of things to watch out for in terms of advances in your industry and what becomes the changes to industry standard over the years, and making sure we're keeping up to date with that. Callum, apologies, I've gone over by 5 minutes. I don't know how many questions there are, but feel free to fire those questions.
No, that's no problem. No, I think it's a really insightful session there. I think it's always worth just reminding ourselves kind of what can go wrong, and the implications of those, and also like the learnings that can be taken as well.
Yeah.
So thanks for providing that
You're welcome.
detailed presentation there. So yeah, so over to questions. So guys, there's a Q&A box there at the top of Teams, which you can see. So feel free to put any and all questions in there. We've got around 10 minutes, so we'll try and get through as many as we can. And the first one that I've got here is around like evidence. So evidence to regulators and courts. Like, is there any changes you can foresee there for 2026? Where health and safety managers and directors basically need to effectively demonstrate that health and safety is being managed effectively and not just documented.
Yeah, I mean, I think AI may come into this, that there might be some changes there in terms of the standard of evidence that's expected. I think that will happen over the coming years, probably possibly not this year, but it's definitely something to watch out for. I think obviously evidence from a lawyer's perspective, we're not all about evidence, but it's obviously exceptionally important that it's soul destroying when you go into an organization, you see that they're doing things really well, and we've had an incident, and then we can't prove or demonstrate that we've done the things that we were doing. You can introduce witness evidence to confirm that you did X, Y, and Z. Training is a great example. It often happens that there's no documents signed off, and toolbox talks, all those kind of things. But getting the evidence is absolutely essential. So, but yeah, I think that AI may help with this, may make it a bit easier in terms of gathering the evidence, collating the evidence, and making sure that we can use that going forward. But what I will say is things like trends is something that I know some organizations are using AI for, to identify trends, which is very important. You need to understand where your incidents when they're happening and whether there's some trends building. But so there's some interesting conversations around that as well in terms of spotting those trends and making sure that you're taking the appropriate action as a result.
Cool. Thank you very much. So we've got the next one from Philippa here. So do you have any specific statistics on the number of education premises prosecuted or subject to enforcement action from the HSE?
I don't, from my research for this particular talk, and I haven't gathered them together, but obviously you get a lot of educational cases coming through, and the thing about cases though, in terms of learning from the cases, I tend not to focus too much on the industry, because you've seen from those cases that we looked at there, that organizations, where you've got an occasional task, that was a local authority that was prosecuted there, but could very easily have been an educational trust. But yeah, I mean, if you want to have a private chat about that, I'm very happy to have a conversation with you. I mean, I've dealt with those kind of cases myself, and so if you want to chat through key themes, etc., I'm more than happy to do that separately.
Well, thanks, Emma. I hope that answers your question, Philippa. So the next one, Emma, is around what can health and safety managers do in the next sort of 6 to 12 months? If there's like 3 actions or 3 key takeaways you think that they could do in the next 6 to 12 months to be legally compliant, what would you advise that those are or would be?
the first one is having those conversations about previous cases, and again, it might be something that you do, but a lot of organizations don't do this because again, I genuinely think that a lot of people will genuinely believe that it's just never going to happen to them. And when you start looking at some of these cases and saying, this is absolutely what happened to somebody else, and they must have been in the same position. I mean, the case in relation to pedestrian vehicle segregation, clearly that was the situation because, they're not following the rules, and no one would have expected or thought that, clearly didn't think that that was going to happen. So I think making sure you're having those kind of conversations. I think if you're in those risk areas in relation to the HSE's inspection areas, the inspection focus, I mean, absolutely just making sure that you are, that you're ready for an inspection, because I get so many improvement notices from that. And then I think, yeah, just keeping up to speed. Again, I know that sounds a bit basic, but I've spoken to quite a few CEOs and leaders of organizations, and they say the things that keep them awake at night is what they don't know. That when they know what's happening, they can, or what the risks are, they can take action. But it's when they don't, when they've not kept up to date and they don't know that there's a problem that's happening, or they don't know that there's been a change. So I think making sure that you're aware of what's happening is a basic but really fundamental point to get right.
Well,
Hope that
thanks,
answers
Emma.
that question.
It does indeed, does indeed. Thank you. So this is quite a lengthy one from Victoria. So in the case of evidencing competency of trained staff who haven't got official training records, but years of experience of using specialist equipment, but then looking at official training programs out there are actually less than what they know about the equipment, how can we demonstrate their skills, competency without training records?
So this is really challenging. It'd be interesting to see whether you do any competency checks or sort of tests, practical tests yourselves to in some way formalize what experience, that they're all meeting in a sort of a certain standard. I guess that's what you really want to achieve, isn't it? You want to be able to prove that those people are working to an appropriate standard and that they're all working to that standard, because if one person isn't, then you'll be criticized for not having the standard training. You can imagine a case where someone doesn't do the right thing, and the regulator will say that was covered by the basic course. And I appreciate what you're saying is that it doesn't cover as much as what these guys know. So you might be exposed to a risk there of being where you would have been able to say, we've sent everyone on these courses. I think having some kind of testing program or spot checks or some way of being able to say that we are reaching the required standard and it is consistent across all of the workers or the majority of the workers in the workforce would be helpful, I think. Again, if you want to have a chat about that, I'm more than happy to speak about it separately.
Brilliant, thanks, Emma. Okay, the next one's from Lee. So the workload on health and safety executives is getting more and more day by day. Is there any assistance outside of work for sharing issues or problems within safety?
I mean, industry groups, I think joining organizations like Notify, where they're keeping you up to date with things, in terms of what's happening. But I think that's probably the best way. HSE website is very good. When I look at other regulators, I think the HSE's website is quite good to keep up to date with things. But I think just getting yourself to this kind of event and keeping yourself up to speed with that. But I know what you're saying. I think if you can get to events where you're networking, I think that's particularly helpful. Because as you say, it's what you don't know that's going to be the problem. But yeah, I think about the days before the internet. Which I, was in work before the internet. That's how old I am. But and you just think of how much easier it is now with the internet. But I do appreciate what you're saying. It can be really tough. But having someone regularly checking, setting up Google reminders, sort of checks on certain words and things like that can help for specific issues.
Yeah, perfect. Thanks, Emma. I guess just to add to that, Lee, as well, obviously, Notify have got a community of customers who are all health and safety managers, directors, all within that role who probably face similar challenges. So if you've got ideas and want a community to tap into, just feel free to get in touch and we can hook you up with some of your peers.
That's good.
So we've kind of run out of time for questions. I think there's a couple more in there, but we'll I guess we'll follow up with those after, Emma, which would be great. So yeah, so just before we sign off, I guess just a quick thank you from myself and obviously on behalf of Emma, to everyone for joining today. We hope we found it useful and there are a few key learnings and takeaways. If anyone would like to know or get in touch to them about how Notify can help you stay compliant, you can head over to our website, notifytechnology.com. Or if you'd like to reach out to Emma as well with any questions, you can connect with her on LinkedIn there or reach out direct. Just as a heads up, our next webinar is scheduled for the 2nd of March, and we'll be exploring the importance of reporting, analysing and acting upon near-miss data. So a really key topic there. We'll also be looking at that through 4 key lenses, and that'll be around leadership accountability, legal risk, psychological safety, and of course, digital enablement. Emma will also be a panelist on that call, so please keep an eye out for the registration details coming in the next few weeks. But other than that, thanks again for your time. As always, any feedback on the session or anything that you'd like to learn more about, feel free to get in touch. The more content that we can do to help you guys in your role, and the more we'll do. But other than that, thank you and enjoy the rest of your day.
Thank you.